Court will note that this matter is before the court on the plaintiff's notice for entry of judgment and the UCSO. Mr. Schaefer has filed kind of extensive objection to that. Mr. Toth, if you would, I guess, address the objections and then we can go from there.
I will do so, Your Honor. I've had an opportunity to review the objections that I received Friday afternoon, and I've had an opportunity to go back and look at the what I'm going to call the video transcript. I guess we have the advantage of being able to go back and look again at exactly what Your Honor said. I think, first of all, Your Honor, what I would like to do is to focus on the equalization of the parties, because quite frankly, I think we're actually $32.89 apart. And I'll explain why. Mr. Schaefer's, what he calls his judgment of divorce equalization chart, does not include the award of attorney's fees to his client. If we look at the bottom of the chart where it's $1,342.20 awarded from plaintiff to defendant, what that represents is the Cigna stock. It's the same number. In my view, the $5,000 should be added to that also, because there was an award of $5,000 that was directed to his client. And Your Honor, then unfortunately, what Mr. Schaefer's equalization chart totally ignores was contained on page 8 and 9, even of his proposed judgment, and that's the reimbursement from the defendant to my client for expenses. And the amount of that was $12,556. And that's consistent in both of our judgments, Your Honor. I should say that I went through each of the individual provisions within our judgment, and the numbers are the same. It's the way that Mr. Schaefer has chosen to allocate and apparently ignore. So my view, Your Honor, is this, is that Mr. Schaefer claims that it's $8,571.38 that's owed to the plaintiff, my client, by Mr. Klein. He ignores the $12,556 that is owed from the defendant to the plaintiff. And if you add those numbers together, it's $21,127.38. And if then we subtract the $5,000, the attorney fee that's owed by my client to Mr. Klein, we come up with $16,127.38. Your Honor, my bottom line the bottom line equalization number was $16,094.11. That's $32.89 difference. My number is actually more favorable to Mr. Schaefer's client than his. Again, we're talking $32 or $33. So in essence, Your Honor, when we win it two different ways, and it's unfortunate, but it's consistent with this case. The parties have trouble doing things according to the same process, and apparently the lawyers do also. I've gone through, and I don't quite understand. I understand that maybe Mr. Schaefer missed the reimbursement from defendant to my client, but what I don't understand, Your Honor, is somehow the notion that the attorney fee should not be offset. And I had an opportunity to go over the video. And at the outset of the hearing, or of your finding, Your Honor, you said, and I'll quote, "After considering offsets and the debt in this particular matter, I will tell the attorneys, I am not going to give you a balance at the end saying this is the amount. You have to go through and take each item of property individually and then offset those to come up with the final number in the end." That was at the outset of the property finding in the case, Your Honor. And then I'll jump to the very end of the proceeding, and that happened at the 1 hour, 30 minute, and 34 second portion of the hearing. And this was a situation where Mr. Schaefer was asking for clarification about the attorney fees to be paid. And Your Honor stated, and this is specifically, again, I'll quote, well, what happens is we are going to have to calculate and offset all these things. So I don't know, but the court would order that that would be paid within 90 days from today's date. The court referenced offset at the very first moment of your finding, and pursuant to the question from Mr. Schaefer, the subject matter of offset comes up again. So as a consequence of that, Your Honor, my belief again is that why aren't we including the attorney fee in the offset? It's illogical. Everything else, Mr. Schaefer or the defendant agrees should be subject to offset, but it's that one item that isn't. And it's illogical, Your Honor, and it's absolutely inconsistent, not only with the theme that you identified for us when we first appeared before you, but it's also contrary to the specific answer to the inquiry by Mr. Schaefer. And I'll simply repeat that I will tell the attorneys I am not going to, well, I'm sorry, it goes back to the 130-34 portion of the hearing. And we're going to have to calculate and offset all these things. And that's exactly the way I approached your finding, Your Honor. And again, I think that if we include the $12,556 reimbursement from defendant to Ms. Klein, and if we offset the attorney fee award, our numbers are very, very similar. So I would suggest, Your Honor, overall, we've arrived at the same place. And Mr. Schaefer would, again, I don't understand why the offset would not apply to the attorney fee. So that would be my overall general impression, Your Honor. I would state that there's been no objection that I think we both have the same numbers for the two child support orders. And now I would move on to spousal support. Your Honor, I went back and listened to the video, and I will concede that at that point, or in regard to the spousal support, quote, the court will grant to defendant transitional spousal support in the amount of $36,000 in gross payable at a rate of $1,000 per month. This amount is not subject to modification, is forever barred after the 36 months. So the form that I submitted and that was objected to talked about termination at death or remarriage. I'll acknowledge that was not in the video. As a consequence of that, Your Honor, I would look at it as follows. If in fact it was the intent that that's an alimony and gross award, I think the easiest way to handle the $16,094.11 offset would be to offset that against the alimony. It's a lot cleaner and it's a lot easier, and it really addresses this argument regarding the various tax rates. So if it's an alimony and gross award, there's no reason that shouldn't be included in the offset. It's a lot easier than the gross up or the gross down, or however you want to look at it, comparing the pre-tax dollars to the post-tax dollars. So I think that would be, again, the cleanest and the easiest way would be to simply have that money that's owed after it's all said and done of the post-tax dollars of $16,094.11. It could be just offset against the alimony, and we don't have to go on to the adjusting the retirement award. It could remain at that $41,000. Now that brings me to another objection that's been stated by Mr. Schaefer, and that's number 6. And it has to do with the gross up, if you will. And that is that he somehow believes that it should be a 12% rate of the defendant. Well, Your Honor, the actual rate is not 12%. And I'm quoting the Internal Revenue Service, and this is available to everybody. And from the actual rate is 22% for Mr. Klein, because he earns more than $41,776. So somehow, if his tax rate should apply, then it actually should be the 22%, and when you add in the state tax, my 25% that I used is actually a good number. Actually, it's favorable to him. But that being said, Your Honor, it really makes no sense that we're talking about using defendant's tax rate for anything. And again, I want to be clear that the reason that this is an issue is because at the end of the day, my client owes the defendant $41,000 or such in pre-tax dollars in retirement. And Mr. Schaefer's client owes my client approximately $16,000 in post-tax dollars. And so we come up with our apples and oranges evaluation of this. So the question becomes, what is the amount of money that's going to have to be paid that would provide my client with the $16,000 in post-tax dollars, since it's coming from pre-tax dollars? So again, this is all applies to the plaintiff. It has nothing to do with Mr. Schaefer's client's tax rate. And so the idea here is what we have done is to say that to get the equivalent of the $16,000 in retirement money, it has to be grossed up. And that's basically what I did, Your Honor. I used my client's federal tax rate. I used the state tax rate, and she works in the city of Battle Creek, and so she has the 1% tax. Again, the 25% is more favorable to Mr. Klein than if we took the specific tax rates. But we're willing to go with the 25% if the court is so inclined. And so to try to synthesize what we're talking about, Your Honor, is I would say, number one, Mr. Schaefer and I are on the same page with ultimately the amount of money in post-tax dollars that are owed by Mr. Klein to Ms. Klein. It's, again, he's not willing to go along with this notion that the court on 2 occasions specifically made reference that these numbers are to be offset. So that's number one. Number two is now we're talking about how is that money going to get paid? In my judgment, I said that the offset should be against the retirement. However, based upon the objection filed by Mr. Schaefer, if we're talking about alimony and gross, I think the far easier way would be to simply offset $16,094.11 against the alimony obligation. And then we can give up talking about gross ups and whose tax rate should be used. If the court is disinclined to go that way, then it's illogical that Mr. Schaefer's tax rate enters into any of this, because it's the impact on my client that we're talking about. If the court is inclined to use the tax rate of Mr. Klein, I go back to the IRS tax table, and this additional income to him based upon his current rate of income, the federal part of that would be 22% alone, and then we move to this up to the state level. And I think that the easiest way would be to offset the money against the alimony. However, if the court's not so inclined, I'd argue my client's tax rate should be used. If Mr. Schaefer's client's tax rate is going to be used, it starts at 22% and not 12%. So I would move on. We've talked about the attorney fee. Clearly, the ruling of the bench was offset should be work in this case. And again, I go back to the very end where the court made it clear, pursuant to Mr. Schaefer's question, that the attorney fee was going to be subject to offset. We talked about the Cigna stock awards, and I went back and looked, and Mr. Schaefer is correct as to the years that were talked about. I don't think it makes a difference, because in regard to the Cigna award, that was an area where the court was absolutely crystal clear on the amount of the stock that his client had an interest in. So as the court made its ruling, there was a specific number that was used, and that was the $1,342.20. Both of our judgments identify that fact. It was simply the continued statement when we're talking about the Cigna stock. And again, I went back and looked at this, and the court first of all identified that one quote, $1,342.20 would be payable to the defendant. And plaintiff, my client, is entitled to 2 additional stock distributions, one on March 1, 2024, and one on March 1, 2025. I added in 2023. I'll acknowledge that. I think it should be included. I don't think at the end of the day it makes any difference as it relates to the objection. The page 2, the communication regarding how these parties are going to try to communicate. Again, court quote, the court would order that the parties would communicate through an app, and I will leave it up to them, whether it is Our Family Wizard or WhatsApp or some other third-party app. If not, they can bring the matter back. That was what the court said, and if we're going to have to come back to court to identify what app we're going to use, then so be it. So I would acknowledge that that was the ruling of the court, and my order was specific. I wish there was an alternative that was suggested by Mr. Schaefer, to be totally honest, but that hasn't come forth. So that addresses the communication. I will acknowledge again that the court did not say we're going to use My Family Wizard, but so that needs to be changed. I've already talked about the equalization. Mr. Schaefer's objecting to the support, but again, the court was very, very clear. And I guess he's waived that objection because he hasn't objected to the support orders. But the court made it clear that what it had in front of it was the 2021 income. And I went through and looked at the exhibits that were admitted into evidence, and there was no year-end 2022 that was admitted into evidence. And the court said, well, if Mr. Klein moves, you'll have to come back in. And so if the idea here is if these objections are that this judgment has to have full fidelity to every word that was said during your ruling, then I would say that if the 2021 income is appropriate in establishing support, and both of our orders actually reflect that. I think that leaves us with the we've talked about the equalization amounts. That leaves us to the personal property. So in regard to the personal property, Your Honor, and I would reference, it was 12/14/22 hearing, beginning at page 85, where I was cross-examining Mr. Klein as it relates to the property. And I'll now refer to your ruling on the 14th of February. And it's, and I'll quote, plaintiff has complained that she didn't receive all of the items on the list that she was to receive. The chop saw, the other was a Milwaukee grinder, there was a leaf blower, and I believe there were a couple of other items as well. And I'll say that again, I believe there were a couple of other items as well. And those are the items that I addressed during my cross-examination of Mr. Klein. And what I would say is that my judgment included the items that were referred to during that cross-examination. And perhaps the easiest is the ratchet straps. On page 91 of the transcript from the 14th of December, Mr. Klein goes on to say, give them all to her if it makes it. So I included those items that were referenced on that particular date. The keys to the Raptor, the testimony was that Mr. Klein had the title and the keys, and we wanted them back, and I included that. And I would say, Your Honor, that I did then bring that up after your ruling, and I had a question in regard to the Raptor. The testimony was that both the title and the keys are within the defendant's possession. Could the judgment provide that those items be turned over within 30 days? your response was, quote, "You can include Mr. Toth in that standard provision about the parties cooperating." Well, I didn't include it in that paragraph. I included it just on the list of personal property. Keys and a title are personal property. So I'm not sure if the objection is that I didn't include the Raptor title and keys in another portion of the judgment, or if it's that his client shouldn't have to turn it over and or it shouldn't be referenced in the judgment, Your Honor. So, Your Honor, my belief is that the court made it clear that there were other items that my client claimed she didn't get, and that's why I included those in the judgment. So what took us, Your Honor, the better part of a year to get through with testimony, I think now there are extensive objections, but I think we really have an opportunity to simplify this. If we offset attorney's fees, and if we offset the Cigna stock, and if we offset what the defendant it owes my client against the alimony award, then we can just simply have the $41,000 transferred pursuant to the language that you had in your finding on the retirement money, and that makes it easy. If we're going to go the transfer pre-tax dollars to my client to make up for post-tax dollars, there has to be a gross up. And I've identified 3 ways that I've looked at it, and I don't think any of them make a heck of a lot of difference at the end of the day. I would, Your Honor, like an opportunity at some point this morning to have the court offer some clarity on perhaps another issue, and that has to do with the parenting time schedule. Your ruling changed it. It was actually just about a month ago. My experience over 35, 36 years, however long it has been, is that when a judge makes a ruling from a bench and on a parenting time schedule, the parties adopt it. Consistent with everything in this case, Mr. Klein insists that until the judge's name is on an order, that the temporary order applies that relates to parenting time. So I would ask, Your Honor, whether it's now or whether it's some other time, if the court could offer some clarity, because it's creating another huge issue. My position is simply that the court's identified what the schedule should be. It should be effective now, because it could be another month before we get this judgment signed. Thank you.
Okay, thank you. Mr. Schaefer?
Your Honor, again, I guess the history of this is that it took us the better part of the year to try this thing. There was a lot of testimony. And I guess let me address the argument of easy versus what was ordered. The 2 items, the attorney fees and the spousal support. I believe that Your Honor's ruling was the offset of property. That's what Mr. Toth read when he went back. This is not property. And there's a distinction. Easy is not the remedy here, is that the attorney fees and the spousal support were there to assist current money obligations. Especially the spousal support was a transitional time period because of the lack of income and the lack of property that he was awarded in this particular matter. To say, oh, let's just set it that is easy, does not help out the current cash flow. And that's why the spousal support should be that which the judge ruled, which is $1,000 a month for 3 years. That is important to my client, to have a cash flow, not in some retirement program that he will benefit from when he is 60 years old. Same thing with the attorney fees. As argued at the time that they were awarded, there have been substantial attorney fees in this particular matter. That is a current financial obligation that my client has. It makes sense that it not be offset, and the court did not do that. He set a time that the attorney fees should be paid within 90 days. I asked that be continued. All the other offset had to do with trying to justify the property issues in this particular matter, and they should be. Now, I don't believe that I missed the $12,000 figure. Go back and review that. I think I spent a lot of time just verifying numbers, and I'll give Mr. Toth credit. I think his numbers were on the money, but it took me about 3 hours to go back and review each of those numbers. I don't agree with his equalization chart. I don't think that was accurate. I suggest that my equalization chart is accurate in that regard. We did it different ways. In all due respect, I think mine is a simpler way to acknowledge what was. I took the assets, practical standpoint. His client is getting all the current money in this particular matter. My client, only thing that he gets are assets that are in property form at the present time. And so I think it is important that that number be accurate in this regard. And I think mine is accurate in that regard. I will, at the argument of Mr. Toth, go back and review my numbers again, but I don't think that I missed that matter. In response to the other items, yes, I think they ought to be accurate based on your honor's ruling. In all due respect, I did object to the amount of income allocated to for child support. Your honor admitted that it was the 21 amount, which is inaccurate. The temporary order used the 158 figure and determination, and exhibit 47 of plaintiffs had the $24,000 bonus plus the other taxable amount, and the 158 I think was an accepted number in that regard. If that, I agree that your honor did not order that. If your honor is reflecting that, you could, I put that in there so it would be changed and be accurate now. Otherwise, once it's entered, I'll be back in front of the court saying, your honor, you made a palpable error in this regard, and here's the evidence that it should be made on. I am trying to get at least part of this finalized, and the 158 number is the accurate number that had been testified to by a number of exhibits and the various parties. That is why that is there. I did not change it in my proposed judgment because it is probably a reconsideration motion because your honor made a ruling, although I don't believe it was consistent with the evidence. The personal property, in all due respect, there was a list of property that was stipulated to that each party got, and that was by agreement. And there are a lot of items on that going both ways. In all due respect, they haven't been all divided up yet. Your honor made a interim ruling about 3 items. That was your honor's ruling. That should be accurate in the judgment. There probably will be post-judgment motions to enforce, including the $25,000 worth of property of snowmobiles and Rubicons and whatever else that are still in the possession of the plaintiff that should go to the defendant. But again, those are post-judgment matters. So the ruling of the court should be accurate. And that's why the Signa stock is important, that it be accurate what your honor ruled. It's important that the wizard or third app be accurate because that's what your honor ruled. And we need to deal with that. The fact that you argue, well, it's easier, I didn't get a counter. We haven't got the judgment in yet, and there's going to be some post-judgment things to deal with this. But the attorney fees and the spousal support are not property items, and I don't think they're subject to the offset. And I would respectfully suggest that The personal property, in my judgment, is consistent with what your honor ruled, and I would ask that be part of the order. Your Honor, I think we've all spent a lot of time trying to deal with the numbers in this particular matter. And I think as best as I have been able to cipher through review and your honor's ruling, I am submitting that my judgment is appropriate judgment should be entered. I take exception that Mr. Toth is bringing up ancillary issues at this point in time. There's going to be a lot of post-judgment issues, and I ask that it not be ruled on today because there is important input in this particular matter, and there may be requests for additional things to take place based on the change in circumstance over this 9 months that we have tried this particular matter. Your Honor, those are my responses. I would respectfully indicate that my judgment is consistent with your honor's rulings, and I would ask that be entered.
Okay, thank you. Well, what the court's going to do is the court does note, and Mr. Toth has referenced the record, which is helpful. The court did intend to, again, offset issues concerning property. I didn't intend to offset the issues concerning the attorney fees or spousal support, as the court had stated that, again, the attorney fees of $5,000 would be paid within 90 days of the finding. So, yes, I can understand the language, but it wasn't the intent that that would be offset or that the spousal support would be offset. The court would not offset those two particular matters. The personal property, that issue, the court had intended that would be the property that the parties had agreed upon at the prior hearing. I think that was the December 14, 2022 hearing that we went through the property, etc. I don't think there was a dispute on that, although there was a dispute as to what property that was going to the plaintiff, what the defendant had, and that was the intent for clarifying with some of those other items. But the court would, in fact, order that the items that the parties agreed to and put on the record at that December 14, 2022 hearing would be the property that would be exchanged. And if it's not, then again, the party would be responsible, the opposing party would be responsible for the value of the property not exchanged. That would include the title of the Raptor and the keys, which Mr. Toth had apparently included on his list. That's fine to put it on the list so that those get exchanged and provided to the plaintiff. As it relates to the communication app, I think the language as referenced by Mr. Toth is correct. It was Our Family Wizard or another one if they could agree. If they can't agree, then it would be Our Family Wizard. I guess Mr. Schaefer will have to look back to see if the reimbursement of the $12,556 is included in those particular numbers that Mr. Toth has provided. If they're not, then it should be. But if it is, then you can basically do that. The court would likewise, as it relates to equalization, if in fact we're dealing with pre-tax and post-tax, the court does believe that there should be a reduction for equalization based upon tax rate. The court does believe that the 25% that Mr. Toth used is appropriate in this matter for reduction purposes, and the court would so order. Again, I don't know what that leaves us in the end as far as the total, and I don't know if the attorneys do at this particular point until it's recalculated and refigured, but I think that addresses all of the objections in this matter. And I would address the fact that on income, the court had used the plaintiff's 2021, as I stated, as I reviewed the records and stuff. That is all that I had. I didn't have any 2022, which the court would utilize again in the future in the event that that's brought forward. And that's changed, but as of the time of my ruling, I was using the 2021. Mr. Toth, does that give you a better understanding as to what you need to do to recalculate all this and to prepare a revised judgment?
I do have, I would like a bit of clarification, Your Honor. What I can say immediately is that my calculation with the $16,094.11 included giving Mr. Klein credit for the attorney fee obligation. So that number is going to change with the court's ruling because so there's going to be a $5,000 change there. I understand the 25%. Your Honors, I understand the ruling in regard to the personal property. So let me reference my judgment.
Well, the intent, Mr. Toth, as I stated, is back on the December 14th, when, again, you cross-examined the defendant about all of the items of personal property, but we had an agreement we placed on the record as to those lists. Again, I wasn't going to go through each and every item of personal property. The intent was whatever the list was that we had that they agreed upon, that would be the list of personal property that they would each get. And in fact, because your client had testified she didn't have various items, that the court ruled that those items would be turned over, or that in fact there would be a value ascribed to those and he would be responsible for that. I tried to do the best I could based upon all of the testimony documents we had.
Your Honor, what we had in this case is we actually had an order that divided personal property and that was entered months before the conclusion of the trial in this case. The list that I went through on the 14th were items from that court order that my client never received.
Okay.
So it wasn't necessarily limited to what stipulations were placed on the record on the 14th, because it basically governed the titled, other than the walk behind mower, it was all things that had been titled. So I just wanted to make it clear, as I understand, the judgment should include
it should include that order that we did, which was the list of those items.
and that's in there. In regard to, for example, we talk about the drone and the ratchet straps and gun safe with key and shop lights, et cetera. That should, if I understand what your ruling is that should not be included. It should simply be the items that you specifically identified. And then I should add a provision that says, in addition to anything that was placed on the record on the 14th. And I guess my question is there was no stipulation regarding placed on the record on the 14th regarding drones and handgun safe, et cetera. That had been memorialized by a previous order.
Right.
My concern
we'll go back to that order.
Okay,
my concern is to go to the order, which was the agreement on those two lists.
Got it.
With the exception of the testimony onto those other items.
Got it. Okay, I understand. And as I understand it, I can specifically include the title and the keys to the Raptor.
Correct.
And let me just, I only want to do this one more time. Your Honor, I had asked for some clarity regarding the implementation of your order, and that's not outside of anything. We have a problem. We have a problem with Mr. Klein playing games where my client gets a call. My client needs to know what the parenting time schedule is, and consistent with the practice in this county and every other county I practice in. If the court makes a ruling regarding parenting time, it should be respected from the time of the ruling. Because there could be that's simply my question. That's simply my question, Your Honor.
Okay, was the intent that ruling would take place? It would be effective the date I gave the ruling, notwithstanding I mean, if you'd have had the judgment done in a day, it would have been in effect that day. If it took a month, again, the ruling would still be effective, but again, the court ruled on the parenting time, and that's what I expected the parenting time to be.
And that would be effective presently then, Your Honor?
Yes. Can
Thank
be
you.
effective presently.
The, let me just see if there's any other.
According to my list, I think that takes care of everything, Mr.
All right,
Toth.
Your Honor, I will, I'll run some calculations and we'll resubmit a proposed judgment for Mr. Schaefer's consideration.
Okay,
Your Honor, I have some responses, please.
okay, go ahead.
On the personal property, I believe Your Honor said that whatever's on the order that was stipulated to. And it
Correct.
was for both clients, that if they are not turned over, then the value would go through and it worked both ways.
I'm not gonna utilize that one way and not the other way.
Okay, very good. So it's both ways, that they are either turned over the value, that correct?
Yes,
Okay, very good. And you made comment about the wizard and the third act. You said that you thought that Mr. Toth's language was accurate. I don't believe it is. He says it is the wizard and.
no,
Your Honor-
I meant when we were talking about, he referenced the ruling, and that would have been the correct determination on that. It would be our family wizard or a third app, whatever the parties could agree that, and if they can't, and I said at that point, if they can't, then they can bring it back and we'll make a determination.
Okay, very good. Thanks for that clarification.
Okay. Thank you, gentlemen. We'll end at 10:15 a.m. You're free to go. Have a good day.
Thank you.